So what is patent claim construction? My name is Steve Hansen. I've been a practicing patent attorney for over 25 years. Not only do I write patents, but I tear apart other people's patents in litigation. If you like this content, please do me a favor and like, follow, and share. We're going to pivot a little bit in this patent law series to the patent infringement litigation process a bit. We've covered a lot of the basics of what a patent is, how it works, how you tell a good one from a bad one, etc. But, in terms of enforcing your rights and monetizing patents, the litigation process and understanding it is really important. And it's really important to know what your options are and how the different procedural mechanisms can really affect the outcome. Because there's a lot of strategy to where you bring a case and how you litigate the case. So in this first little bit, I want to talk about patent claim construction and what it is. Patent claim construction is a process by which the court, as a matter of law, decides what claim terms mean, what their definitions are. And then the jury takes those claim constructions that the judge decides and applies those claim constructions to the accused product to determine whether it infringes, and to the prior art to determine if that prior art invalidates the claims for lack of novelty or obviousness. So claim construction typically happens early in a case, so it's really important to understand the accused products and the prior art to figure out what your claim constructions should mean, and to try to get them to get the court to agree with you and hold that your definitions are correct. So I just want to show you an example of what a claim construction issue looks like from a case I worked on over 20 years ago. It involved airbag covers. And so let's take a look at this patent. It was for a snap-on airbag cover. So this is U.S. Patent 5501485. It's for a snap-on airbag cover. It's a patent I litigated early in my career over 20 years ago. And the issue in this case, at least as it pertained to this patent, was with Claim 11, and there was a phrase, homogeneous thermoplastic molded body. And the parties had two different interpretations of what that meant. And depending on which party's interpretation you picked, the accused airbag covers would either fall within or without the scope of the claim. So the plaintiff, patent holder, argued that homogeneous thermoplastic molded body simply meant that the airbag cover was made out of thermoplastic throughout, even if there was more than one thermoplastic, it was just entirely made of thermoplastic. Our argument as defendants was that homogeneous thermoplastic molded body meant that the cover had to be made out of a single type of thermoplastic. There couldn't be multiple thermoplastics in it. And this was important because the accused covers for our client were two-shot covers, meaning they had two layers of different thermoplastics that were molded together in an injection molding machine. So that was the issue in that case. That's claim construction. We'll talk a little bit about how you do it and what the rules are in a couple of other videos. But that's it for now. I hope that helps to keep you out of trouble, and I hope to see you here soon.